name is Crystal Alanis, and I am a partner with Reddy Neumann PC, practicing exclusively in employment-based immigration law. I am also the managing attorney for our PERM labor certification department, where I oversee all EB2 and EB3 employment-based green card matters. And I've actually been with Reddy and Neumann for 11 years now. So just a brief overview, the PERM labor certification process requires a sponsoring employer to test the U.S. labor market through various recruitment methods for able, willing, qualified, and available U.S. workers. If no such workers are found after conducting good faith recruitment, an employer can file a PERM labor certification application on ETA Form 9089 on behalf of the employee beneficiary. As part of the recruitment process, employers are required to post an advertisement for the position in multiple recruitment mediums. That's actually mandated by the Department of Labor. Once the recruitment process begins, employers may start to receive resumes from applicants. So today I want to discuss the top 5 recruitment questions I receive from employers going through the PERM labor certification recruitment process. Okay, so we'll just jump right in here. Number 1. Can the beneficiary of the PERM application be involved in the recruitment process? So this is going to be an absolute no. The beneficiary cannot be involved in any way in the recruitment process. So this is going to include receiving resumes, reviewing resumes, conducting interviews, or just being included in the review process at all. The beneficiary's involvement in the recruitment process would create an undue influence over the PERM process, and that's why it's strictly forbidden by the Department of Labor. 2. Can I disqualify an applicant for being overqualified? So no, an employer cannot disqualify an applicant for being overqualified. During real-world recruitment, an employer would normally be able to disqualify an applicant for being overqualified, but we all know that real-world recruitment is very different from PERM recruitment. Employers can actually only disqualify U.S. workers for lawful job-related reasons during the PERM process. So this means that an employer must only analyze an applicant's qualifications against the minimum requirements set for the position. So this is why it's going to be really important to properly draft the details and minimum requirements for the sponsored position from the beginning of the process. 3. Do I have to consider H-1B workers and F-1 students who have employment authorization? So no, you only need to consider U.S. workers for the job opportunity. For example, a U.S. worker, per the Department of Labor regulations, is a worker who is a U.S. citizen, a U.S. national, a lawful permanent resident, an individual admitted as a refugee, and an individual who is granted asylum. So employers really need to be very careful here when determining whether an applicant is a U.S. worker. It's important to not ask specific questions about the applicant's citizenship or immigration status during the hiring process so that you're not violating any anti-discrimination laws. According to the Department of Labor, an employer should only verify whether an applicant is legally authorized to work in the U.S. So some examples of what an employer may ask are you legally authorized to work in the U.S.? Or will you now or in the future require sponsorship to work in the U.S.? Examples of what employers may not ask are, are you either a U.S. citizen or a green card holder? Are you authorized to work on an unrestricted basis? And what is your citizenship status? So you can't ask any of those questions. And then, of course, you should always speak to an immigration attorney before requesting information from an applicant. Number 4. Do I have to consider an applicant if a review of their resume indicates that they are not minimally qualified for the job opportunity? So here it's really going to depend. If an applicant clearly lacks all minimum requirements for the position in terms of education, experience, and training, and skills, then the applicant may not have to be contacted. On the other hand, if employers will be required to reach out to applicants if on the face of the resume it appears that the applicant may be qualified for the position. So for example, if the applicant meets the education requirement but the employer is unsure as to whether the applicant meets the experience requirement, the employer is going to be obligated in that case to inquire further. Another example, if an applicant appears to reach a broad range of education, experience, and training, then the employer will also be obligated to inquire further into the applicant's qualifications. So here it's really going to be on a case-by-case basis. And finally, number 5. If a U.S. worker is found for the position, can I hire the applicant for another role within the company and still file a PERM application on behalf of the beneficiary? So the short answer here is going to be no. An employer cannot circumvent the PERM recruitment process by simply considering the applicant for another role. If the applicant applied for the PERM position, they must be considered and included in the PERM recruitment report. So this doesn't mean that the employer cannot ultimately hire the applicant for a different position within the company, but the employer may not be able to proceed with the PERM filing for the beneficiary. So these are the top 5 PERM recruitment questions that I get from employers. So just a quick note, the PERM labor certification process is usually the biggest hurdle to clear through the 3 steps of the PERM-based green card process, because it's very lengthy and involves multiple stages and really requires careful strategizing to avoid missteps along the way. So if you are starting the PERM labor certification process, it's always best to contact a qualified immigration attorney. Thank you very much for your time today. I hope you found this information helpful. And for additional information regarding immigration, please visit us at rnlawgroup.com. Thank you.